Certain officers think they can get away with anything, but the courtroom holds surprises they're not ready for. In this video, we'll see cases where corrupt cops face instant judgment in the presence of a judge. Starting with this over-enthusiastic cop who thought he could do whatever he wanted in the courtroom.
The investigation for false imprisonment, assault in the third degree, assault as a Class 2 felony, and a misdemeanor charge as well in possession of drug paraphernalia.
I'd like to object first. If I'm under investigation, I thought the investigation came first, and then the rest came.
Right.
Get on your feet. You don't turn on me. Get on your feet. Get on your feet. Get on your feet.
Oh, man.
Get on your feet.
My head's open.
Deputy Lovingier's actions were completely out of line and uncalled for. It was clear from the footage that Anthony posed no threat to anyone in that courtroom. Judge Doris Bird filed a complaint against Deputy Lovingier for excessive force, which led to a 30-day suspension. Anthony Waller later won $50,000 in a lawsuit, with the jury ruling his rights were violated. And as for Waller's original crime, he was sentenced to 2 years in county jail for third-degree assault. Civilians cannot feel safe when cops are the biggest threat, even to their own family, and this officer crossed every line with his actions.
I'm sorry to inform you, but your wife is passed, sir. No, God damn it!
On February 2, 2021, an Idaho State police officer at that time, Daniel Howard, called 911, saying his 52-year-old wife Kendi had shot herself. The police arrived fast, but what they discovered next was truly shocking.
Come on out, sir. Over here, come on. I initially talked to Mr. Howard outside the front door, and then I walked past him into the house. Sit up here, okay? Let me see you. Looked around the living room, didn't see her, and I didn't remember exactly where she was supposed to be, so I went back out. Sir? And so then I went back upstairs and found her.
And can you describe what you saw in the bathroom?
I saw a woman naked in the bathtub with an apparent gunshot wound. There was blood around her, coming out of her mouth.
According to the officer's description, Kendi's death was brutal and heartbreaking. The poor lady suffered in a way no one deserves.
The gun laying to the right of her in the water, and there was the water was tinted red. Once her pulse was checked, no pulse was found by Deputy 9. Called for medical, and then they came in and announced that she was deceased. And then we cleared the residence upstairs to make sure no one else was in the house. I'm sorry to inform you, but your wife is passed, sir. No, God damn it! Hey, Dan. Hey, Dan. Is there anyone that we can call for you? Anyone that can attest to my kids? Oh, God. Do it. Is there anyone we can call to give you some support or anything like that? Any family that...
It was hard to believe when Daniel claimed he didn't realize it was a gunshot, even though he was a cop. His crying seemed fake, like he was acting too dramatic. He didn't seem truly upset at all.
I'm not that monster, I assure you, that people are portraying me to be. Kenny and I had 28 years together, and raised a family, had mostly a good marriage and a good life. I worked away from home all the time, and I was gone, and that was probably the gist of most of my problems, that I was gone. But I'm not that animal that they officer for 28 years and not being here before the court way beforehand.
Howard always had a bad history. He resigned from the police due to theft charges, spent time in jail for harassment, and was later booked as a fugitive.
It is not my intention to anger the court or disrespect the process that I used to believe in and worked for. But Your Honor is about to sentence an innocent man to prison. And I love my wife, and I miss her. And my stepdaughter Brooke, who I raised since an infant, and her daughter Kinley, that I helped raise for 5 years when we took them into our house. And I will miss them very much. I do miss them. Words cannot describe the pain that I feel for that.
When police began investigating, they found that Kendi's fatal gunshot wound was not a suicide. This led to Howard surrendering to authorities in April 2023.
I stand before you, shell of a man I used to be. Hell, I don't even have a shell left. My wife took her life. My will to live went down significantly. And when the jury found me guilty of crimes I didn't commit, it went down even further. Mr. Johnson touched on this. I appreciate the court taking into consideration my service.
Howard was such a monster that he continued to lie to the judge, blaming the innocent woman he brutally murdered for her own suicide. It was horrific.
To the state of Idaho for over 20 years, in which I was decorated multiple times for saving lives, not taking them. For service to the community through coaching football and baseball for many years and being a 4-H leader for many years. Volunteered to help the seniors in the community north of me. Every time there was a windstorm, I'd cut trees from the driveway, from around the house. And I volunteered a lot. And to the frustration of my wife sometimes, because I was gone even more away from home. I didn't ask those people to write letters into the court because I didn't want to burden them. So that's why I'm telling you that now.
Given Howard's history of multiple arrests for harassment and other crimes, it was clear he was lying about being a good cop who saved people. Everything he said was a lie.
I have successfully completed probation before, like Mr. Johnson has said, and I can successfully complete probation and parole in the future, I assure you. I just want to reiterate that I still love Kendi's side of the family, Janie, Wendell, Brian. I still love my stepdaughter. I miss them very much.
We're here for sentencing on a conviction of second degree, a conviction of domestic violence, a felony. And what the jury found, Mr. Howard, is that your wife. Now, why they found a second degree murder versus first degree was, I mean, I'm not there in the jury room, but they didn't find beyond a reasonable doubt the one element of premeditation.
Howard's lies were unbearable. It was obvious he was a cold-blooded murderer with no feelings for his family, let alone for Kendi's family. It seemed like he never felt any real emotion at all.
They found specifically, it was part of the charging documents and part of the jury instructions, that you asphyxiated your wife, that you strangled her, that you killed your wife. And so The state has argued a lot about, we don't know exactly what happened that night, how she obtained the bruising, the burn, the broken jaw.
The judge listened carefully to everything Howard said and then responded in a very polite manner. He was incredibly professional, articulate, and educated, showing great poise.
Your attorney disputes the state's version of how she got those injuries. We don't know for sure. But what we know, beyond a reasonable doubt, is that you strangled your wife, you murdered her, and then you staged her naked body in the bathtub, shot her through the mouth. Often in horrible crimes like this, everybody wants to know why. And often we don't know why. And I can't get inside your brain, but the pretty clear evidence, I agree with the state, is that this was due to, jealousy, greed, pride, anger, revenge, some combination of that.
As per reports, Howard killed his wife because she planned to divorce him and marry someone else she loved. She was leaving due to Howard's mistakes, and he couldn't handle it. Out of jealousy, he murdered her. He was also concerned about their shared assets, which totaled around $2 million.
And you in a brutal manner. And as I think about it, when you killed your wife, when you killed Andy, you didn't just kill your wife. You killed a mother, you killed a grandmother, you killed a sister, you killed a daughter, you killed a coworker, you killed somebody who brought a lot of life and light. This was without the state proving necessarily, and they don't have to, without them proving exactly how she received what they describe as this beating, without them proving exactly how she ended up with a body so badly bruised.
Not only did Howard want to kill Kendi, but he also tortured her and abused her in every way he could, showing that he was an absolute monster.
We know you strangled your wife, you killed her, and you staged her to look like suicide. We don't have to know the answers to all those other things to understand this was a heinous, outrageous murder. My view of the evidence and from what came out, despite your efforts at the time to appear emotional and sad and distraught, it's clear to me that you're a remorseless killer. And I don't say that lightly.
It was right when the judge called out Howard because when given a chance to speak, he never apologized. He didn't say sorry or admitted he made a mistake. Instead, he tried to justify himself as a good person, showing he had no remorse for what he did.
But you're not sorry, and I don't. The way you treated her family, the way you treated your own family, your own stepdaughter, your granddaughter, with a cold and callous contempt after the murder, it belies your argument to me today that you love these people and that you're sorry about this after the fact. Your behavior towards her was contemptuous and unkind, and I'm not sentencing you for that. There was a lot of stuff that came in at the trial as to how you treated people after the fact and how you treated your stepdaughter after the fact. And
Howard showed no emotion or regret for his action. He didn't shed a single tear for his brutal act. Instead, he looked like he was proud of what he had done.
But that does point to the remorse, the lack of remorse, the lack of caring, and just the callous disregard that you had for Kendi and how her death affected those around her. Goals of sentencing include the primary consideration of the protection of society, followed by the possibility of risk reduction through rehabilitation, deterrence of the individual and the public generally, in punishment or retribution for wrongdoing and the impact on the victim.
It was an inhuman act that no one could imagine, yet Howard dared to do it to his own wife, the woman he had spent half his life with. It was unbelievable.
In terms of protection of society, I mean, obviously society has to be protected from somebody who's willing to commit the ultimate crime of murder. If, I was just say, if they feel threatened, you didn't even feel threatened. This is over, again, most likely, elements of greed and anger and revenge. I look at the possibility of risk reduction through rehabilitation. And to be frank, in your case, rehabilitation is not a factor. I'm considering that significantly. And again, this might be a different case if you were, 25 years old. But you're 58 years old, and
people like Howard don't deserve rehabilitation or a chance at redemption. No matter their age, such monsters should always be punished for their actions.
I don't know how to say this without just sounding mean, but I mean, this is who you are. When I read the PSIs, I read that, and these are, obviously the PSI included a lot of reports. But these are actual quotes you gave to law enforcement 10 years ago. The first one I got, page 79 of 162. When this is your neighbor who you were angry with. Now this is him. I said these were quotes from you. This isn't a quote from you. This is what he says you told him. Wood claimed Daniel Howard yelled at him, "I don't know where you are at, but I'm going to find you and kill you for your life. When you least expect it, I will find you."
Howard's claims of being a good cop who saved lives were totally bogus. The judge made sure to confront those lies and back them up with the facts. When
confronted about this, among a number of things you said, this is a text you sent to another individual, quote, "I used incredible restraint because the weasel is still breathing." So this is 10 years ago. You're talking about somebody is still alive because you used incredible restraint. You denied the statement and said the following, quote, "I don't know how many people I told that he's lucky that basically he's breathing because I choose to let him to. Dumb, I mean, I never threatened to kill him." But you were telling people he's breathing because you choose to let him to. You went on to say, and then this really jumped out at me because this is 10 years before your wife.
Given Howard's history of multiple arrests, it was easy for everyone to believe what the judge was saying. Howard was a sick individual who treated people terribly while he was in charge.
I look back at these guys and I'm thinking, these guys that get put in prison because they killed old ladies who they were with? I'm like, you know what? Man, I understand a certain amount why now. Those thoughts going through my mind, yeah, it's not illegal to think that, let me tell you something. So 10 years before, you're saying you understand guys, their wives. That was page 29 of 162. This is on page 95 of 162. And this is the sergeant's comments is part of this interview with you about your behavior, the stalking behavior that they were investigating of your neighbor. It says, "During this long pause, Daniel Howard attempted to look disgusted and in emotional pain, but appeared feigned, and he would abruptly recover to continue his interview."
Throughout the verdict, it was clear on Howard's face that he was owning every word the judge said. The worst part was that he showed no regret for any of his crimes.
Interestingly, I read in the PSI writer experienced this as well. numerous times during his interview, he appeared to be feigning emotions of sadness, but he would quickly change his demeanor and direct the conversation back to himself. And it's like, wow, this is what we saw at trial.
The judge was excellent and extremely professional at his job, making sure to confront and expose that liar in front of everyone.
And so you're 58 years old. I don't see a lot of rehabilitation, sadly, in your future. Maybe, I mean, perhaps, but that's not a significant mitigating factor in sentencing you. Deterrence of the individual and the public generally, certainly I consider deterrence. I almost rarely talk about deterring the public as a whole, because usually people don't pay attention to what's happening on a day-to-day basis here in court.
Considering Howard's narcissistic behavior, his emotions could never be real, and he couldn't truly upset anyone. He showed no remorse, not at the time of his wife's death or while sitting in the courtroom.
In your situation, people are. And the public needs to know that there is a severe punishment for your wife. And there's no sort of mitigation because the marriage is on the rocks or...
Howard deserved severe punishment, not just for being a cold-hearted murderer, but he was also a big threat to the public. Monsters like him should always be behind bars.
Punishment or retribution for wrongdoing and the impact on the victim. As has been noted by our courts, a judge really only has complete information when it comes to retribution and deterrence, because those are based on the nature of the offense. I can't otherwise get inside your head. And there's a lot that went on in this case that we don't know. We don't know how, Kendi got the injuries on her feet, on her head, all over her body. There's a lot of those things we don't know. You strangled or asphyxiated your wife. You staged her body to be found as if it were suicide. It's an outrageously egregious murder. And of course, all murder is, but this is particularly heinous in my view, having sat through the trial and seen all the evidence.
It was satisfying to see the judge call Howard the names he deserved. He was truly a heinous murderer who didn't deserve a single chance, not even for a second.
Sometimes the nature and gravity of the offense standing alone is sufficient to justify a fixed life sentence. And that is what I'm going to impose here. I think Kendi's family deserves to have that closure. The crime is so egregious that I don't think you should be released at any point. There's just so little mitigation here. There's just really none. And so I do find that a fixed life sentence is appropriate for the count of murder in the second degree. On the domestic violence charge, I'll impose 10-year sentence and run it concurrent. I didn't even speak about that. I mean, really, I'm not...
Although that last case was horrific to witness, it's only the tip of the iceberg, as these next cops face judgment for their dirty crimes.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody.
We need more dedicated judges like him who are passionate about serving the public and standing up for justice. It's time to show corrupt cops that their actions will be punished.
No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be right there with me. Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Hurdle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take it on.
This is what dirty cops like him deserve, to rot in jail until their demise. Thanks to the judge's fierce decision, people across the states can rest peacefully knowing that we are in good hands. If you think this cop was tough, then watch this next one who thoroughly exposed the criminal cop before giving him a fierce sentence.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree.
On Friday, March 4th, 2022, former Kansas City police detective Eric DeValconaire, who was convicted in November of Cameron Lamb in Kansas City, Missouri, appeared in front of Judge Dale Youngs. The way the judge hands down the sentence is a sight to behold.
There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option.
Lamb, 26, was backing his pickup truck into his garage when DeValconaire shot several times, and he died.
At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence, in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. And as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offenses described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house.
DeValconaire said Lamb was armed, but the prosecutors believe that the firearm found near him was placed there intentionally.
Negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family.
The judge did a great job of explaining to everyone that he was not biased against the officer. He also mentioned the impact on the deceased family, so both sides felt heard.
And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
Sir.
Eric DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
DeValconaire was sentenced to 3 years for the involuntary manslaughter conviction and 6 years for armed action. Although the sentence sounds short, his life after getting out was essentially over. If you think this officer had it bad, then wait till you see this next officer who was being cross-examined for arresting George Floyd.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Derek Chauvin is the officer who previously arrested George Floyd. He was a former Minneapolis police officer involved in Floyd's fatal arrest on May 25, 2020, where he knelt on Floyd's neck for over 9 minutes while Floyd was handcuffed and pleading for air.
Testified that you were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't, man, I don't want to get shot."
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Well, and yes.
This incident led to widespread protests and calls for police reform across the United States and globally. Watch how Chauvin's expressions change as he gets cross-checked.
And then he put his hands on his head, right?
That's correct, yes.
And there was one officer who said that they were going to take him, right?
That's what I heard, yes.
And you were yelling pretty loud, correct?
Yes, I was, yes. It escalated real quick.
Some profanity as well, correct?
Yes.
And you had your gun drawn the whole time you were giving commands, right?
Once I started ordering him and he refused to show me his hands, yes, eventually it escalated where I pulled my gun, yes, ma'am.
And he was awake, correct?
What's that, ma'am?
Mr. Floyd was awake. Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
He continued to talk to you. While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
Wait a minute, what was the question? Can you speak up a little louder, ma'am?
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop while you were interacting with him, correct?
No.
Thank you. Nothing further.
Chauvin was charged with multiple offenses, including second-degree unintentional, third-degree murder, and second-degree manslaughter. He was convicted on all counts in April 20th, 21, and subsequently sentenced to 22.5 years in prison for his role in Floyd's death. Next up, we have the case of an ex-cop who was involved in one of the most heinous things an officer could do.
Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter.
In October 20th, 19, former Fort Worth police officer Aaron Dean appeared in front of a Texas jury for fatally shooting Tatiana Jefferson in October 20th, 19. His guilty verdict was a rare conviction of an officer for killing someone who was also armed.
Good afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor. The defense is ready, Judge.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict. Is that correct?
Correct.
Is it a unanimous verdict?
Yes, Your Honor.
Okay. Can you hand it please to Deputy Nicholson? Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict.
Notice how the devil cop failed to show any emotions. It's as if he didn't want anyone to see that they could get to him.
Number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict?
Yes, Your Honor.
Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? You may be seated. Thank you very much.
In this next case, these dumb and evil cops get owned by slick lawyers.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that.
Before the shootings?
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
You back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those four people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so.
That you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over.
Correct.
You'd agree you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
It looked ridiculously stupid that the prosecutor brought up evidence that had already been ruled out. It was hard to believe Binger even went to law school after that blunder.
Do you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case. Mr. Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I ask the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
Mr.
Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
The defense could see that Prosecutor Binger was ruining his own case by clashing with the judge. All that arguing was seen as extremely disrespectful and only made Binger look worse.
In my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right, I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes...
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want...
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out.
The prosecutor should have been disbarred for his outrageous behavior. He seemed to be trying to provoke a mistrial by challenging the defendant's right to remain silent. Judge Bruce was right to yell at him. His actions were completely unacceptable.
This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because made that more relevant, you would admit it or at least consider it an admittance. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence.
Binger struggled to prove Rittenhouse's guilt, but the judge remained professional and honest, upholding the principle of innocent until proven guilty.
I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in. No matter what you think. With what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
It was hilarious watching Schroeder repeatedly explain the laws and rules to the prosecutor, who still didn't get anything right. Binger made so many terrible mistakes during the hearing. Schroeder and Binger clashed repeatedly during the trial. Schroeder slammed Binger for violating Rittenhouse's right to remain silent and for bringing up evidence that had been ruled out. Binger later accused Schroeder of unfairness in handling evidence. Despite Binger's promise not to comment after the verdict, Rittenhouse was acquitted on all charges 3 days later. We often see cops afraid of being filmed. This next case shows exactly why.
Do hereby find the defendant Michael Amiot guilty of a misdemeanor of the first degree.
In August 20th, 2017, Officer Michael Amiot faced charges for a brutal traffic stop where cell phone video showed him repeatedly punching Richard Hubbard after pulling him over. During the trial, Amiot was convicted of assault, interfering with civil rights, but he was cleared of a second assault charge.
You may be seated. Ladies and gentlemen of the jury, you've advised the bailiff that you've arrived at a verdict. Have you arrived at a verdict?
Yes, sir.
If you would, please pass it to the bailiff. The heading in the Euclid Municipal Court, Cuyahoga County, Ohio, State of Ohio, plaintiff. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiot, not guilty of assault, a misdemeanor of the first degree in violation of Section 2903.13a of the Ohio Revised Code, as charged in Count 1. We do so render our verdict this 29th day of July, signed by all 8 jurors. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiot, guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13a of the Ohio Revised Code, as charged in Count 2. Verdict. We, the jury, being duly impaneled and sworn, do hereby find the defendant, Michael Amiot, guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45a of the Ohio Revised Code, as charged in Count 3. We do so render our verdict this 29th day of July, 2022. Signed by all 8 jurors. Ladies and gentlemen of the jury, are these your verdicts?
Yes, sir.
On behalf of the state, do you wish the jury polled?
No, Your Honor.
On behalf of the defendant, do you wish the jury polled?
Yes, Your Honor.
Juror number 1, is this your verdict?
Yes, it is, Your Honor.
Are these your verdicts, I should say?
Yes.
Juror number 2, are these your verdicts?
Yes.
Juror number 3, are these your verdicts?
Yes, Your Honor.
It was a clear case of justice served. Being an authority didn't give anyone the right to ignore the law and act on their own whims.
Anything further of the jury? Ladies and gentlemen of the jury, I want to thank you all for performing your civic duty. One of the things that I will say is that you've done your job. You came, you heard the evidence, you applied the law, you made a decision. The prosecutor had a job, the defense attorney had a job. Your job was not to prove anything or disprove anything. Your job was to determine what was presented to you, determine the facts, apply the law, render a verdict. You did that. You should leave feeling that you've done your job. No second guessing, you've done your job. If someone else didn't, that's not your job. You've done it. If you'd like to hang around a few minutes and talk with me, I will do that. If you do not, that's entirely understandable. Sometimes the lawyers would like to talk with you to determine how they came across to you. But again, that is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything?
No, Your Honor.
Ladies and gentlemen of the jury, thank you very much. You're discharged at this time. If you want to wait in the jury room, I'll meet with you later. With that, you're discharged. All rise. You may be seated. Based upon the verdicts rendered by the judge, the jury, the court at this time will enter on, with respect to count 1, a finding of not guilty, count 2 and count 3, the court will enter a finding of guilty. The court will set this matter out for sentencing, given the fact that under Ohio law, the victim has the right to make a statement or present anything he may wish to present to the court. The court will request the Cuyahoga County Common Pleas Court Probation Department to submit to the court any documents or any information that it wishes to submit with respect to pre-sentence investigation or what have you.
The verdict was based on video evidence from citizens, proving why it's crucial to record police interactions. Cameras don't lie, and it's clear why cops are often afraid of being filmed.
It's under the judge. The judge recused himself. It is better that we maintain the appearance of appropriateness in requesting that that be done by the Cuyahoga County Common Pleas Court. Anything else, the court will consult with the attorneys and the court administrator and set this matter over for sentencing at a date that's agreeable for everyone. Anything else on behalf of the state? Anything on behalf of the defendant? If there was a bond or no bond, it'll continue as stated. I want to thank everybody for their conduct. I know it got a little contentious at times.
The other officers in the hearing were stunned. It should have served as a wake-up call that cops could no longer escape accountability for their actions. Amiot was sentenced to 1 year of non-reporting community control and fired from the Euclid Police Department. He was later reinstated to the warrant unit. Richard Hubbard received $450,000 in a legal settlement. It was later found out that Amiot had a history of excessive force complaints and had resigned from a previous police job as well. Being a cop means catching criminals, but this next officer became one instead.
I'm about to hurt you.
On October 27, 2018, Daniel McKenzie, Mario Godoy, a 32-year-old suspect who had already been handcuffed and placed in the back of a police vehicle for trying to break into cars at a Roswell apartment complex. McKenzie and punched the handcuffed suspect, admitting to the assault during the investigation. He resigned from the Roswell Police Department shortly after. McKenzie was arrested on February 28, 2022, and later sentenced to 12 months in prison for battery and simple battery. He also received 5 years probation for aggravated assault, making a false statement, and 2 counts of violation of oath by a public officer. No one can escape justice, not even cops, as this next case proves.
Kevin Perez committed a battery upon him, so he won't have to account for his own behavior.
A jury of 3 men and 3 women found Miami Beach police officer Kevin Perez guilty of simple battery, a first-degree misdemeanor. This verdict came after State Attorney Catherine Fernandez-Rundle emphasized that the guilty verdict was a strong message against excessive force in arrests. Perez could face up to 1 year in jail, 12 months probation, and a $1,000 fine. Initially charged with third-degree felony battery, which could have led to up to 5 years in prison, the prosecutors couldn't meet the required standards for that charge. The charges stemmed from an arrest incident on July 26, 2021 at the Royal Palm Hotel, where Perez was accused of punching a tourist. Although Perez was found guilty, the judge granted him a new trial, with sentencing still pending.
This case is about the beating of an unarmed, handcuffed black man, Delonta Crudup, by an overzealous police officer, Kevin Perez.
Delonta Crudup has every incentive to say that Kevin Perez committed a battery upon him, so he won't have to account for his own behavior.
It is very, very obvious what he has on his mind. And it's retaliation.
Maintaining decorum in court is a cop's duty, but these next 2 did the exact opposite. At the Tonawanda City Courthouse near Buffalo, New York, a routine day turned chaotic when a dispute arose between Officer Michael Lewandowski and a couple. Lewandowski reportedly ordered the couple to leave, but they refused. He then forcibly removed the man from his seat and shoved the woman against the courtroom door. In the hallway, Lewandowski struck the man and slammed the woman's head into a cinder block wall. Despite her protests, both were handcuffed and taken away without charges or explanations. Lewandowski was initially suspended for 10 days for excessive force, but this was later reduced to 5 days after he agreed to bias training. The surveillance footage, not released at the time, came to light 4 years later, showing further misconduct. Consequently, the Tonawanda Town Board decided to fire Lewandowski after 4 years. As a cop, you're supposed to resolve conflicts, not create them, but this next officer chose to go violent over personal matters.
I was never ever expected to be grabbed from the back and thrown from side to side, to a point where I was yelling at the top of my lungs, help, help.
Former Miami police officer Lester Bonenblust, 51 years old, was sentenced to 45 days in jail, 3 years of probation, and 100 hours of community service for assaulting nurse James Nicholson at Jackson Memorial Hospital in May 2018. The altercation began when Bonenblust's niece was denied readmission after being discharged. Frustrated, Bonenblust arrived in uniform, and when Nicholson refused to discuss the patient, grabbed him and slammed him to the ground. Bonenblust accepted responsibility in court, but Nicholson stated the attack should never have happened, especially to a healthcare worker.
I was never ever expected to be grabbed from the back and thrown from side to side, to a point where I was yelling at the top of my lungs, help! Help!
From catching murderers to trying to become one, this next cop took things to a whole new level.
Spanning from 1998 to this year represents the worst that we could possibly expect from someone in our society.
On May 23, 2013, former Edison police officer Michael Dotro set fire to the home of his superior officer, Captain Anderco, while the captain, his wife, 2 children, and 92-year-old mother were asleep. Fortunately, no one was hurt in the 4 a.m. fire. Dotro was arrested and, after a long trial, sentenced to 20 years in prison for attempted murder and aggravated arson. He will have to serve 17 years before being eligible for parole. In addition to the 20-year sentence, Dotro received 10 years for official misconduct, 5 years for conspiracy to tamper with a witness, and 18 months for conspiracy to retaliate. He will also face 5 years of parole supervision after his release and is banned from contacting the Anderco family or any other victims. Throughout his sentencing, Dotro showed no remorse and said nothing in court.
I understand where I'm coming from with regards to this, especially if there's going to be any appellate review of this sentence. I want those judges to know the sentence to be imposed in this particular case is because Mr. Dotro, through his conduct and his admissions, spanning from 1998 to this year, represents the worst that we could possibly expect from someone in our society. Yes, he's caused very specific damage to Captain Anderco and his family, to Ms. Zog, to Ms. Dotro, to his own parents, to his families, to his brothers. But what he's really done, and what we're going to be left with after he's walking out the door to spend the next third of his life in prison, is allow people a basis to say that our system of justice has no integrity. How could it when we've allowed this particular individual like him here in Middlesex County, here in Edison, to do the things that he's done?
The last case was intense, but not as heated as this next case gets, where a judge has had enough of the lies by a dirty cop and his lawyer.
Mr. Brigandi, if you give up all those rights today and thereby give up the right to have a trial, there's never going to be a trial in these matters, sir, and instead we are going to resolve it all here this morning. You understand that?
Yes.
You're joining with your lawyer, sir, in pleading no contest to this disorderly conduct charge back from September the 8th, 2009?
Yes.
Brian Pergand agreed to plead no contest to accusations of what, you ask? Let's hear it from him.
What is it specifically that you did that you're causing you to plead no contest to disorderly conduct here today, Mr. Brigandi?
I took photos that were eventually blown up, I believe.
What?
I took photos of a female that I arrested.
Why would you plead no contest to a charge of disorderly conduct for having done that?
I guess I broke policy, and I guess I made her feel uncomfortable, Your Honor.
Why would you have made her feel uncomfortable, sir?
I don't know. She was fully clothed.
Pergand was sentenced to serve 30 days behind bars for disorderly conduct. He pleaded no contest to that charge after he was originally charged with felony misconduct in office. The judge wasn't the harshest with the officer despite his disgusting act, but this next one definitely was when he found out what the officer had done.
That is not true.
I'm dismissing. I'm dismissing. I am dismissing this charge.
In 2014, Lizette Gonzalez was charged with driving under the influence after she was observed drinking beer while driving. Officer Michael Wagner testified that he witnessed Gonzalez consuming alcohol and subsequently arrested her. After the verdict was reached, Gonzalez's attorney made a final plea.
Your Honor, not enough evidence presented for the jury to find the verdicts that they did. They didn't do all the field sobriety examinations that should have been done. I respectfully ask that this court grant the judgment notwithstanding the verdict.
The attorney revealed that Gonzalez had not given a breathalyzer at all, and neither had her blood drawn. So based on this information, the judge made a decision.
This isn't a purely circumstantial case, and so I'm going to deny the motion for JOA. Now, we have this other case for driving while license suspended.
Next, the judge mentioned that Gonzalez was driving with a suspended license, but that only happened because the arresting officer Wagner submitted a false report. When Wagner's attorney tries defending him, though, the judge loses his cool.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case, or am I going to get mad at you today?
You get mad at me, Your Honor, but at this point...
Why wouldn't you... Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
The attorney was plain disrespectful to the judge, but these tactics were not going to save her. Watch how the judge shuts her up.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm granting.
the charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
I don't agree with the state's decision on
I'm
the
granting the
other charge.
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion, the JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
Thank you, Your Honor.
The case should have never been done. Never.
Thank you for letting us know that, Your Honor.
It's mind-blowing that some of these attorneys will go to any length to protect the evilest of people. Thanks to the judge's sensibility, Gonzalez walked out of that room free of all charges. This cop might have had it easy, but this next cop definitely didn't.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree.
Friday, March 2022, former Kansas City police detective Eric DeValconaire, who was convicted in November of killing Cameron Lamb in Kansas City, Missouri, appeared in front of Judge Dale Youngs. The way the judge hands it down will leave you stunned.
There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValconaire killed him. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel. Cameron Lamb's death.
Lamb, 26, was backing his pickup truck into his garage when DeValconaire shot him several times, him in the process.
Also, as I'm weighing all these facts, it can't be overlooked that the offense of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. They were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this, a fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb.
It's just heartbreaking to hear the judge describe the whole situation like that in the middle of court.
The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. And Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. The circumstances of the offense as described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover.
DeValconaire claimed that Lamb was armed, but the prosecutors suspect that the firearm discovered near him was deliberately placed there.
Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do, his natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account.
The judge really impressed everyone with his clear explanation that he was not biased against the officer. He also made sure to acknowledge the impact on the deceased family, which really helped both sides feel heard.
And that is to consider the totality of the circumstances and to consider the totality of the defendant's life. The facts and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is dead. Eric DeValconaire killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct. I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
None from the state.
No, sir.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
DeValconaire was sentenced to 3 years for the involuntary manslaughter and 6 years for armed criminal action. Although the sentence sounds short, his life after getting out was essentially over. The judge definitely knew how to make the victims feel heard, but this next judge did that even better.
Joke about his injuries as it were wiping blood off their uniforms with disinfectant.
On January 28, 2015, an ex-cop, William Melendez, and his partner stopped Floyd Dent for a minor offense. But this stop turned into something completely different. As William appeared in court, the judge went through the situation again, the details of which will leave you stunned.
January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenowski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head. He was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed.
The details of the incidents kept getting shocking as the judge continued speaking. Just hear what the officers did after doing what they did.
The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. In disbelief of what had occurred to him. What crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking to do a nigger. As Police Officer John Zelenowski, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up niggas right now. LOL."
What makes the situation bad is that the officers had no shame in what they did. They were actually enjoying their gruesome acts openly.
How does this happen? On January 28, 2015, you did not fulfill your job. You performed Just Us, a game that began with a police stop. The purpose of it was to harass and degrade a motorist in Inkster, the man chosen for your game. Let's follow a car in a known drug area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a gun or drugs in a vehicle. Upon stopping Mr. Dent, you knew, and upon stopping Mr. Dent, who was dead wrong for driving with no license,
you could already tell that the judge was infuriated by this devil cop's actions. What he did was so low that even the judge couldn't hide the disgust on her face.
Upon being stopped, Mr. Dent put his hands out of the driver's window in plain view. Your partner and you pulled him out. When he didn't move fast enough for you, you refer to it as resisting. I call it bowing down to your command. You utilized your dirty, hairy tactics and used excessive force to arrest him. Your job was twofold. Investigate the situation, be a positive example to Officer Zelenowski, kicking and tasing and ultimately throwing Mr. Dent into a windshield of a police car with a dash cam, which I refer to as the eye of justice. You were so into your bravado that you forgot the eye of justice was watching you and recording this disgusting beating seeing Mr. Dent slammed into the window shield with blood running down his face.
This was also a hate crime because of the text messages exchanged. The officers were openly delighted in the most sadistic way at the black man's suffering.
Fist busting after taking him down as a sign of bravery was just another cowardly act caught by the eye of justice. You knew better. You were better trained than any of those officers out there. You were more experienced. Took me several days to read the letters that people sent talking about your character, about the man that you are. 3 of those letters, I believe, were from African Americans, and 1 even professed to be like a mother. 1 or 2 things, either they're all racist or there's something redeeming about you that somehow in some way you forgot that night. The way you denigrated that man was awful. Who would know and who would care about a lone black man being assaulted by upstanding police officers? Boy, were you wrong.
We need more judges like her in our country today. She fearlessly stated the obvious and courageously addressed all the issues that everyone else was avoiding.
At the station, the other eye of justice captured you and your posse making fun of Mr. Dent, mimicking him struggling while you all wiped the blood off your uniforms with disinfectant while he watched. Such an awesome, caring, properly trained police officer. You led your fellow officers down a path of cowardly behavior. But today you will pay for it. There's an old saying, it ain't no fun when the rabbit's got the gun. It's equally applicable when he has the video. The eye of justice in this case. You betrayed your city. You caused your lovely wife heartache. And you caused Mr. Dent severe anguish. And finally, in the words of Vicki Yost, your commander, accountability is required to ensure continued community trust and healing.
Following a long verbal lashing, the judge ultimately handed down a punishment to Melendez, and his response is truly worth watching.
But only you and God can change your character. I've had an opportunity to listen to both sides. And I had to say this because I didn't say this during the trial. But it was my privilege to be able to oversee this trial because I had great lawyers, and great lawyers make jobs real easy. I am going to commit you to the Michigan Department of Corrections. However, after weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. The court's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
This next case reveals how these corrupt cops are exposed for their lack of knowledge of the Constitution and their policy enforcing mindset.
Sir. Hey, how you doing, officers?
Good.
Can I get your names and badge numbers?
Sure, can I have your ID, please?
No, you can't.
Excuse me?
Have you not heard that before?
I've heard it plenty of times. It's just, I'm surprised because, well, my name and my badge number's right here.
Uh-huh.
Okay, you see it?
Tibbetts?
Yep, 640.
The pen is blocking the number.
Oh.
640?
Yep.
And Dennis, 647.
So I was told that you were asked to leave.
Okay, so would you like to know...
Is that correct?
Would you like to know what I'm doing here, sir?
Were you asked to leave?
Sir, would you like to know what I'm doing here?
I'd like to answer my question.
Sir, this is a public library. Okay, I see where this is going.
I want you to answer my question.
I see where this is going.
Were you asked to leave?
I see where this is going. Security asked you to leave, and the employees asked you to leave, sir? No.
Were you asked?
I was not. Would you like him to leave, sir? Sure.
I didn't know that.
It goes law, goes the Constitution, law, then policies. Okay.
I have no idea.
Okay.
And I have a constitutional right to be filming here. So.
Okay.
Great. So I'm just letting you know. Well, I'm letting you know because you don't know the Constitution, obviously. So.
Obviously I don't. No,
You took an oath to it, though, Tibbets.
Jeez.
Dude, why you gotta be such a tyrant?
You gotta be such a tyrant. See what I'm doing there?
Acting like a child?
Yeah, so we're
Acting like a child.
We have a supervisor coming out here to appease your request.
Yeah, great. Right, we're not friends. You're my servant, right?
Oh.
You're my public servant.
That's right.
You're here to protect and serve me.
Sure am. And I'm also here to protect and serve them too.
So I don't need protection. I don't need protection. So that's that means
sure you're going to be okay and these people are going to be okay.
Because I don't need protection. That only leaves one more thing. You're here to serve me.
As you'll soon see, the whole department was corrupt. All of them were hell-bent on snatching Sean's rights. But things didn't stop there.
Listen, I don't...
Do you know what that law is?
Why don't you tell me?
It's interfering with the duties of a police officer. We now have to find out who you are.
So you know what I'm going to do?
No.
Listen, you guys obviously don't know what you're talking about. But what I'm going to do is, if you lawfully, you just lawfully detained me, I don't break the law. So
You just asked for a supervisor.
No, but it doesn't. You just detained me. This is an illegal detainment, and
It's
it
not
started.
because I need to find out who you are now.
Okay, lower your voice. We're in the library.
I'm just saying.
Okay, just calm down. Use your de-escalation, man. Come on, what are you doing? Just listen.
De-escalation what? You're now just...
Dude,
it's not going to end well with you. I'll be honest with you. We're just not going to walk away and you walk out of there and put all your stuff on your blogs. You're not doing it.
Okay.
I'm just letting you know.
Okay, so I'm detained though.
Yes, you are.
Okay. Do you know that a threat of arrest, like say if you threaten to arrest me and then to give your ID and then I give it to you, that is criminal because you threatened to arrest me.
I'm just letting you know. I'm just letting you know right now.
Okay.
That if we don't get it, we're going to have to arrest
I'm going to let you know. I'm going to let you know that to get my ID, you need reasonable, articulable suspicion that I've committed a crime.
You have.
What crime have I committed?
If you're not going to give me your ID, you're interfering with the duties of a police officer. I'm trying.
I would love for you to do that. I would love. Hey, Sergeant, how you doing? Good. Nice to meet you, sir. Hey, I just say Sergeant Dickinson? Yes. All right, thank you, sir.
Okay, so they would like you to leave?
Okay. Sergeant,
Hey, how about you let the sergeant speak?
Okay, how about you mind your business?
Are you going to leave?
Hold on.
Are you going to leave, yes or no?
If I don't leave, will I be arrested?
Yes, you're trespassing.
Okay, I'm going to leave then. Because you're under threat of arrest.
That's correct, yes.
Under threat of arrest, I'm going to leave. And no, you do not.
Hold on.
Well, don't touch me.
Don't
touch. No, you don't. No, you don't.
We have to
I have not committed a crime.
Yes, you have.
No, I haven't. Listen, man, you're touching me.
They asked you to leave.
They asked you to leave.
And I'm leaving under threat of arrest.
Okay, you're refusing to provide identification to us. We need
because I haven't committed a crime.
Back here because they don't want you coming back here.
Sergeant, I haven't committed a crime. Unless I've committed a crime, I don't have to show you ID, sir.
Wow, the most unprofessional police force I've ever seen. That sergeant had no control over his subordinates. At least he could have asked them to be polite, but he did the exact opposite.
Tell you not to go anywhere, you don't go nowhere. You understand?
Don't touch me. Don't touch me.
Do you understand that, though?
I'm telling you. Do you understand that I told you not to touch me?
Do you understand that?
Don't touch me.
You don't leave until we say so.
Don't touch me. Nobody's scared of you, Tibbets.
No one's supposed to be scared of me. I'm talking over you because you keep yapping.
Okay.
You're not listening. You're here to sit here and preach about everything. You know the law.
I do.
You don't even know what simple trespass is.
I do. I do know the law. Unfortunately, more than you. I'm sorry.
Okay.
If under threat of arrest, I will provide you with my ID. I'm going to go in my pocket now and grab my ID.
Okay.
No, I think you know you're wrong
No.
now.
No. I don't know I'm wrong. I don't know I'm wrong. Don't know I'm wrong. You're wrong. And you're getting a complaint on you. And unfortunately, even though you've been reasonable, you still violated my rights here today, sir. And I'll be planning a complaint on you. Everybody's getting a complaint, and I will be filing a lawsuit with the city because everybody's getting a complaint. You're a real bozo, man. You're a real bozo. You're a real bozo.
That's mean, sir. That hurts my feelings.
You guys are both bozos and tyrants. You know that? I got freedom. You're gonna limit my speech. You're gonna limit my speech now. They're not acting professional at all.
Get a real job, said the man who didn't even know the basics of his own job. His childlike behavior came out even more once they were outside the library.
Watch yourself, dude.
If you didn't have that badge and you touched me? If you didn't have that badge and you touched me?
What is that? What are you trying to say?
Dude.
Don't touch me.
What are you trying to say?
Because if you didn't have, you touched me.
What are you trying to say?
I'm trying to leave.
You're trying to leave.
Just go.
I'm trying to leave.
Just go, because it's not good for you.
It's not good for me. It's not good for you. I'm going. I'm going. I'm going. I'm going.
You lose your temper,
I'm
you
going.
start threatening officers.
I'm not threatening. You're a douchebag. You're a douchebag. Yup. Is that against the law? I'm going. I'm going off the property right now. This is what I do.
For a living?
I stand up for my rights, yep.
No.
Mm-hmm.
This is what you do for a living?
You'll see.
Why do you come to
I
Connecticut
promise.
if
I
you're from
promise.
New York?
Because you guys act like tyrants here. This is, in New York, I can go into any public library and they might call the cops, but guess what? The cops know their job over there and they're gonna leave. They've done it plenty of times because they're not stupid. They don't want to open themselves up to a lawsuit.
So they would like you to leave, and that's what we did.
No, but the law protects me to do what I do. You understand?
No.
It's a constitutionally protected activity. It's constitutionally protected activity. If I went in there and I was acting like an asshole,
you're wrong.
Don't touch me. Don't touch me. Don't touch me. Hey, I want to file a complaint against him, Sergeant.
Right, thanks,
He just grabbed my arm. Sergeant, he just grabbed my arm. I want to file a complaint. Sergeant.
After the officers walked away from Sean, they had some pretty rough things to say about him.
I know. He's a one. I'm telling you right now. 5 years ago with this, he would have been on the ground. Absolutely. 10, 15, 20 years ago, that motherfucker dead. His teeth have been missing.
After this, Sean began filing complaints and even protesting in Danbury City, which only made things worse for him.
You have to fill out a form before you can roll a camera, like in the hallways and in but you can't go into a department.
I know exactly the rules on filming.
Yeah, all right, but I'm saying, and you can't disrupt.
So
right now.
That's why I educated you and the officers last time.
They're supposed to give me the forms as we speak. So you can just wait here. Just wait 1 second. I'm sorry.
Your mayor didn't show me respect.
Wait down here.
I'm not waiting anymore.
You're not going upstairs. You're going to wait down here.
Don't touch me.
You show me some respect.
Listen.
Listen, you wait down here.
Hey, don't touch me. I'm just walking in a public building.
You're a panic.
Okay, great. No, by walking.
I don't want you to go upstairs. I have to call upstairs first. I have to
get out of my way.
First.
I'm asking
not
you to
going to
get out of my way.
Get out of my way.
I'm asking you to get out of my way.
Get outside.
Get out of my way.
Get outside. You're not coming down. Do me a favor. Go to engineering. Go around the corner and get somebody. You're not going upstairs. You have to fill out a form first.
I don't need to fill out a form.
You're going to fill out a form.
No, I'm not.
You're not going upstairs, brother.
Don't touch me, man. What do you mean? Is that a threat? Is that a threat?
Go upstairs to the 3rd floor.
Janusa, Phil, relax.
Get probably Dean or get Dean. Okay, 2nd floor. Tell him I need those forms too.
You know you're breaking the law by preventing me from movement, right?
I don't care if
you're not going to do what
I don't care.
You're breaking the law.
If I lose my job, buddy, you're not going to keep going around and
I'll be calling Allied Universal.
Good for you. Good for you.
You'll be back at the hospital.
We have new rules, buddy.
I don't care about your rules.
Well, I know you care. All you care about is yourself.
All I care about is the Constitution. That's all I care about.
You and your Constitution, you can stick it.
Yeah.
You're not going anywhere until you fill out a form.
Okay. I could stick the Constitution. Very American, Phil.
Just imagine that this was their security guard, and even he was corrupted. Just wait till you see what the officers did.
Your city breaks the law.
What Phil has to do with anybody.
Phil's going to jail. Phil's going to jail.
We're just trying.
You'll see.
We're just trying to explain to you what our reasonable policies are. Now we know what they are. So go ahead, walk around the hall.
Great.
Okay, but make sure the rule is that.
Hey, I don't need you to listen. I don't need you to tell me what to do.
Okay, so you understand.
I don't need you to tell me what to do.
Okay. Just want to make it clear because it's a recent development because of
the First Amendment and freedom of press is a recent development for you guys. Come on.
As Sean tried to raise his voice against the tyrant guard, the whole department stood up against him, and eventually he had to face the inevitable.
What's going on? You were just at the PD?
Yeah, I was just at the PD.
Okay. Were you here earlier recording?
Yeah, I was here earlier recording.
And then you went to the PD?
Uh-huh.
And now you're here?
Yeah, I'm here because I wasn't allowed upstairs.
Okay.
So I had to go to PD to file a criminal complaint against this gentleman for assaulting me.
Okay.
So that's why I went to the PD to write a statement. I'm here again because I'm a journalist working on a story. I'm capturing things that are important. That's all.
Okay. Did you record over the counter like they said?
What they're saying, officer, is that I can't even enter into the town hall office and record in the office. Because if I do, they're saying that that is somehow against the law.
Okay.
But as I'm sure you're aware, I'm not putting my phone behind a camera. I'm not in a restricted area. the security guard who assaulted me earlier got in front of me, said, "You can't record in here, you can't record in here." And I was like, "Yes, I can record in here." He's saying that I can't record in the office, in the town hall office.
Right,
That's
I
not
understand.
true.
I understand. Excuse me, sir, what's your name? How can somebody come and record?
Do you guys?
No, turn around. Put your hands behind your back. Put your hands behind your back.
You look like Sutter. You must be his.
No, I'm not. Put your hands behind your back. Thank you. Good. Yeah, I'm just going to put that in your pocket. All right, go. You were told not to go film in the offices. You film in the offices. Okay. Just going to make sure you don't have anything on
There you go. You got the body camera on?
Yes, I do.
I don't see the red light.
Yes, it is. See?
Okay.
There you go. Come on. We got it. No, I'm not buddies with anybody.
Tyrants. You guys just keep on making it worse for yourselves.
Over the counter, what you
I wasn't filming over the counter. I was filming in the office, which the video approved. That's fine.
And they said
just
want to staircase. It's not working. Okay, perfect. Oh, there we go. We'll use the staircase. Yeah, that's fine.
You commit the crime today, and I go away in cuffs. Isn't that justice? You committed the crime today, buddy, and I'm in cuffs. The difference is, when you're arrested later, it's going to be a lawful arrest. This is what's called an unlawful arrest.
Not only did the officer unlawfully arrest Sean, but they also seized his phone. After this incident, Officer Lacabellis was seen helping Phil, the security guard, write a report to prevent his arrest. In the body cam footage, he could be seen repeatedly telling Phil that it was his statement, all the while helping him write it.
So I would start this by saying, I am a security guard for Allied Universal Security Services, and I work at Danbury City Hall, 155 Deer Hill Ave, Danbury, Connecticut. Right? You introduce yourself and what happened. You don't have to go into crazy detail of the past with this guy, this and that. Whatever's pertinent. This is just what's pertinent to the case. A man who I know from prior experience as whatever you know him as, right? Came into the facility, was video recording. He wanted to go upstairs. I tried to stop him. He got in my face. He tried to move past me, and I believed I was doing the right thing by physically stopping him from going up the stairs at City Hall, going further into the building. You follow my drift? This is your letter to the court, so make it good. Okay? I can't write it for you. You have to. This is your words. Who you are, what happened, why you did what you did. You need to articulate why you used physical force in it. No matter how minor, whether it's just, you know, a push or a light, you know, I'm not going to do it to you because then I'm not going to use physical force on you. But he gets in my, I didn't go up there. He kept getting in my say face. That. Yeah, say that. Yeah. And now be mindful that there is a video of the entire thing. Yeah. X and Y. Of course, that someone is not allowed in City Hall filming unless they fill out a form. The forms were not provided to me as of yet. Well, right? And then, no, you got to do it yourself. I'm not, you know, this is, I have enough writing of my own to do. This is your statement. Yeah. And, you know, you need to articulate here what's going on. You touched on it before, but you didn't finish it. Yeah. You have to say you're supposed to do this, that, and the third. He refused all that, proceeded around me, and went to go up the stairs. So I simply tried to stop him from going up the stairs so that he could fill out the appropriate forms. Now, all that is well and good until you start to use force against somebody.
They told me.
This isn't someone wiling out at the hospital. You know what I mean? This is a completely different arena we're in here.
After this, things got better for Sean Reyes. All the charges against him were dropped, and his phone was returned too. Eventually, things reached the court, where a judge saw the full footage of Sergeant Lacabellis doing what he did and got pretty mad.
Mr. Reyes, in so many words, I don't need this. I'm up for a promotion.
I wouldn't say in so many words, but along those lines, yes.
Okay. And what about your involvement in this incident? Were you concerned about pertaining to a promotion?
Well, I'll tell you exactly. After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me. Yes, it's exactly that.
Right. That didn't happen to you, right?
Oh, no, it did.
It did?
Yep.
Okay. The videos involving I think it's Tippett's and Utter, and the statement that if he'd done something 20 years ago, he would have been dead in the back of some
Objection
truck.
is what?
Yes, I did not.
No objection.
Relevance hearsay outside scope of arrest.
Sustain, sustain, sustain. Keep going.
Okay. The incident at the library, were you familiar with what happened there?
Objection. Same all three grounds.
Keep her out of that objection.
There's been some discussion in the trial thus far about the incident at the library and massive question.
And that involved Danbury Police Department police officers, right?
The incident, I'm sorry.
At the library, sir.
Yes, it did.
And you're familiar with the library incident, right?
Yes.
And are you familiar that Mr. Reyes made a complaint about Danbury police officers in that case?
Objection. Relevance.
I want to allow it as...
At the time of this...
Okay, here's how it's going to work. He's going to ask a question. Okay. He may object. I will rule the objection. You don't answer until I rule the objection. Got it. It's going to use your purpose.
As you can see, the sergeant's attorney was in no mood to let the conversation proceed without objection, but the judge shut him up.
In terms of the conduct that occurred in the stairwell, your words to Mr. Reyes was, hey, I don't agree with what he did.
Yeah.
Correct?
Correct.
Phil was wrong.
I don't agree with relevance.
Did you say that?
No, objection. Relevance.
So that's sustained. That's not relevant. And I think the line of questioning, the warrant, Mr. Reyes, was for the fatality. It wasn't just for the incident in the stairwell, right? You're juxtaposing his conduct in the stairwell with Mr. Janusz's conduct in the stairwell. That's what you're doing?
Well, something like that, but I know that we're here for this particular instance about the trespass and focusing, trying to focus on
7/15/21 in total.
Correct.
Okay.
It's nothing to do with Mr. Reyes and what he's charged for, correct?
Objection. Relevance.
I don't understand the question.
I don't understand it. I'm sorry. I'm trying
The question is, the objection is sustained. Anything you do, anything he does, is not relevant to that investigation that day. Be more specific.
Did any investigation that you undertook
With regard to
after July
Mr. Reyes?
15th pertaining to Mr. Reyes, was there any such investigation?
Any investigation that I partook after July 15th.
Correct.
Well, so I'll just give a little diatribe.
Please. I'm going to object to the form of the question. I don't understand it.
Say yes or no.
I don't understand it. Are you asking me if, besides this investigation into this incident on July 15th, were there any other investigations into Mr. Reyes? Is that what you're asking?
Correct.
The judge made the questions look unclear, when in fact they were pretty straightforward. Sean's attorney was simply asking the sergeant if he performed any other investigation after he wrote a warrant for Sean on 15th July. He could have simply said no.
Did you undertake any other investigations regarding Mr. Reyes being the subject of the investigation?
No.
There's your answer.
So you didn't learn anything further about Mr. Reyes and his conduct on July 15th from a subsequent investigation, correct?
I didn't. I may have learned that he was arrested later that day, but it had nothing to do with this investigation.
Okay, that's where I'm going. When Mr. Reyes was arrested, you weren't the arresting officer, right?
No.
And when Mr. Reyes was arrested in the town clerk's office on the 15th of July 2021, you didn't see any of it, correct?
Correct. I was there that day, but I was in a different part of the city. I was on a different.
And so you have no personal knowledge of what occurred, correct?
The specifics of it, no.
Based on that conduct, to have Mr. Reyes arrested, is that what you did?
I'm going to object because that mischaracterized the testimony. He said he had it in the morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question, Tracy.
Sir?
Yes.
You weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection. Ask the answer.
Sustained.
Okay.
We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15th, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can.
Statement objection.
No.
Ask the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
This judge appears to be doing everything possible to hand a victory to the city of Danbury.
Is there a reason you told Mr. Reyes not to go back to City Hall? I think it's on the video. Why did you tell him that? Not to go back to City Hall?
Just because I thought objection, Your Honor. This goes beyond the scope of my cross-examination. I didn't delve into this officer telling anybody to go back to City Hall. It goes beyond the scope of my cross-examination.
As part and parcel, he asked about the whole interview with the guy, with the defendant.
What's discussion in interview and discussion if he likes to coach witnesses? I will allow a question.
Is there a reason why did you tell Mr. Reyes not to return to City Hall?
Objection, Your Honor. What's the relevance of it?
I assume it's preliminary. I will give you some latitude.
There's some preliminary drawing. Is there a reason why you told Mr. Reyes not to return to City Hall?
Objection, Your Honor.
Overruled. Answer the question, people.
Because I didn't think, I knew could, but typically if there's already been an incident between two people, it's in my interest to try and, if I can, tell those two people to stay away from each other. That's just, that's what every police officer does in that. You know, I've told people in similar cases in domestics, look, you can stay here, but it's not a good idea if you do stay here. I'm just trying to, and I said it jokingly, you know, and then it's not.
Let me go back. Let me flip. One moment.
The judge made his decision before the first witness was sworn in. This just shows that the whole city was involved in this scandal to put Sean down.
So the basic news is, guys, is that all 4 criminal charges have been dropped. They still left me with, unfortunately, they still left me with the infractions. So all my exposure is, you know, a $90 ticket if I get found guilty. Oh man, so I do, even though all the criminal charges have been dropped, I wonder why. Because there's no criminal behavior. So I asked my lawyer, I said, you know, why are they doing this? You know, other than the fact that I'm innocent, right? Why is it that they're doing it? It's because it's their strategy. That's what, you know, and if I get found guilty of simple trespass and creating a disturbance, you know, I might have to pay, you know, $90 ticket. But no criminal, you know, charges, no record or anything like that. So, you know, the criminal charges have been dropped. That's a good thing, guys. December 2nd is my trial. December 2nd of this year is my trial, which will be trial by a judge, right? It's going to be a bench trial, not a jury trial. I'm not entitled to a jury trial anymore.
That's all for today. Let me know in the comments below which case was your favorite. And if you liked the video, subscribe so you can take advantage of the next one we have in store for you. Thanks for watching. This is Detective Mystery signing off.